Grandparents in Florida have almost no way to petition courts for visitation with grandchildren, even in the midst of terrible circumstances, such as the murder of their own child. Why is this a problem, and what can we do to change it? Today, we'll look at this issue from 4 perspectives. First, we'll look at one example, a backstory that provides context for addressing this blind spot in Florida law. Then, we'll look at the policy problem itself and discuss options that have already been proposed for handling it and the obstacles that stand in our way. Finally, it's your turn to consider what can be done. Imagine this terrible scenario. Your only son is murdered, leaving his 2 young children, your grandchildren, fatherless. Then, the children's mother, your son's ex-wife, cuts you out of their lives. This leaves you without the only remaining connection to your son, and it leaves your grandchildren without any connection to their father's parents, siblings, aunts, uncles, or cousins. Worse, it leaves your grandchildren without the love and support you always offered, even more important now in this time of grief. Years pass while investigators work to find your son's murderer. Tragically, law enforcement then announced to the public their theory. They have evidence that the ex-wife's family hired hitmen to kill your son so that his ex-wife could have full custody of his children, your grandchildren. There's a lot of evidence, and one of the hitmen even confesses and testifies to his role in the crime and tells investigators who hired them. But despite evidence of the family's involvement, only the 3 people they allegedly hired get arrested. While there's hope that all of your son's killers will be brought to justice, the legal system moves very slowly. More years pass. Your grandchildren are getting older. So are you. Despite many efforts for outreach, your grandchildren's mother doesn't budge. You still cannot talk with your grandchildren or see them. Meanwhile, they continue to be raised by other family members who law enforcement claim are responsible for the murder of their father. What can you do? You think, I want to petition the courts for visitation. But your grandchildren live in Florida. Florida law won't allow you to petition the courts, so you can't do that. This is the policy problem. This is what we are trying to solve today and what we need your help to do. Florida has strong protections for natural parents, meaning unless given good reason, the state won't interfere with the decisions a mom or dad makes for their kids. This is almost always a good thing. That said, Florida does recognize there are times when grandparents have rights too. After all, Florida is home to the largest portion of grandparent-aged residents in the country. Florida law says that grandparents are allowed to petition a court for visitation with grandchildren in 2 very narrow situations. Grandparents can petition the court in Florida if both of the children's parents have died, or if one parent is deceased and the living parent has been convicted of a felony. But what happens when there is still an active investigation and more arrests are expected in the murder of the child's parent? In Florida, unlike in nearly all other states, grandparents have no options at all. Various options have been discussed about how to address unique, tragic cases such as this, but they each have pitfalls. For example, what if grandparents could petition courts for visitation if the living parent was named by law enforcement as a person of interest in the murder of the deceased parent? The problem with this option is due process. You can't take away a parent's rights based on criminal allegations unless they've been given their day in court. Here's another option that's been considered. What if grandparents could petition courts for visitation if one parent died before divorce courts were able to hear a pending motion about custody of the children? This is a circumstance that other states say gives grandparents the right to petition for visitation. The problem with this option is that in Florida, courts have historically ruled that one has to prove harm to the children for it to be considered constitutional. What if grandparents could petition courts for visitation if they're able to demonstrate that there's been harm to the children, or that harm is likely to happen? Couldn't they petition for visitation then? The problem with this option is that if there's suspected harm to the child, far bigger measures have to be taken, such as removing children from harmful people or environments. This goes well beyond visitation alone. It's a challenging catch-22. The likelihood of long-term harm is great in cases like we described here. But grandparents have no rights unless there's proof of immediate harm. Remember, these efforts are not intended to give grandparents the right to visitation with grandchildren. They are only intended to give grandparents the right to petition courts in very narrow, unique circumstances. Then courts decide. And Florida statutes make it very clear. Courts will almost always rule in favor of the natural parents. In 2020, the Florida legislature considered a bill to do just this. Some raised concerns that it might not be constitutional and that bad facts make bad laws. But others point out that so many laws are inspired by terrible events, and that if narrowly crafted, a bill to expand access to courts would pass constitutional tests, as they have done in other states. One family law attorney wrote this: "It should be the court's right, and beyond that, the court's duty, to be able to listen to cases such as these and consider what is in the best interest of kids. It's time for Florida to empower local judges with authority to do what is right on a case-to-case basis. And it's time for lawmakers to correct this legal slight to grandparents, in the Markel case and beyond." It may be as simple as crafting bill language that is very narrow and that limits what courts can prescribe for reasonable visitation in cases where the living parent has no felony convictions. This is where you all come in. Florida's law has a major blind spot. What is appropriate for grandparents and grandchildren in the years while law enforcement investigate murders, announce suspects, and bring culprits to justice? There has to be an answer. Florida's Constitution guarantees two things: parental privacy and rights, and access to the courts. What options exist that would satisfy both of these, that would affirm the rights of parents, but also allow grandparents access to courts, so that courts can decide what makes sense and what is in the best interest of the child, case by case? Other states have done this, with their grandparent visitation laws being upheld by state and federal courts when challenged. It's time for Florida to do the same. If we put our minds together, this committee can be the hero for Florida families who need a voice in court.
My name is Ruth Markel, and I am pleased to appear on behalf of my family today. This year has shown all of us what it feels like to be isolated from family. But as the world becomes safer from COVID, still too many of us face alienation of a different form. There is no vaccine to protect grandparents in circumstances like the ones my family has faced. Our son, Dan Markel, was murdered in 2014. Only some of those responsible for his murder have been convicted, and the investigations are still ongoing. Typically, tragically, our son's ex-wife cut off contact between us and his two children. We miss our grandchildren terribly and grieve their loss of our support and visitation and affection. But unlike in most other states, Florida law doesn't provide us with the ability to petition the courts for visitation. We hope to be a voice for change, to help open up options for grandparents and grandchildren who find themselves in very unique, challenging situations such as ours. We appreciate the work of this committee going forward. Thank you, Senator Book, for your leadership on this issue. And thank you, committee members, for your thoughtful consideration of what can be done.